Indirect Effect by Camilla Chadder. Is indirect effect? Indirect effect is one of three ways in which individuals can enforce their EU rights. Indirect effect, in particular, is an interpretive tool which can be used by individuals who want to rely on directives that they otherwise could not do through means such as direct effect. And they can also bring action against other individuals, which they may not be able to do when relying on directives through direct effect. So this interpretive approach is called the purposive approach. Essentially, it looks to the spirit of the law in question as opposed to the literal meaning that's written word for word on the law. This tool originated in the case of von Colson, where two female social workers were refused jobs in a German state prison because of their gender. The directive failed on the grounds of the Van Gen test and so could not be directly effective. And the ECJ responded to a reference saying that there could be indirect effect and a purposive approach was to be taken when analysing the legislation. You can categorise legislation as implementing or non-implementing. Essentially, it's to do with when you have a directive, you have, for example, 3 years to implement it. So when that time period has passed, any legislation which is on the same topic can be seen as implementing legislation because it implements a directive. Whereas if it comes before the time of the directive has passed, then in a sense is non-implementing. You can see it as it hasn't implemented the directive, as there may be more implementing legislation to come. Distinction between the two types of legislation has been important because the House of Lords has been reluctant in permitting the use of indirect effect in non-implementing legislation, as it would seem unfair on the private individual who has done nothing but abide by the national legislation, as was seen in the case of Duke and GEC Reliance. However, they were happy to apply a purposive approach, indirect effect, for implementing legislation. So this was seen in the case of Lister and Forthroyd, where Lord Keith said words must be read in light of the directive. Also in Picklestone Freeman's, the House of Lords was prepared to interpret certain parts of the Equal Pay Act against its literal meaning. However, this is not the position today. The ECG developed indirect effect further in the Spanish case of Marleasing, where it said national courts must interpret national law in light of any relevant directive as far as possible to do so. In Marleasing, no national law had been passed to comply with the directive, i.e. was concerned with non-implementing legislation, and yet indirect effect was still permitted. This new wider position was confirmed in the UK courts in the case of Webb and EMO. In this case, an employee was sacked because she was pregnant. And at the time, the Sex Discrimination Act 1975 had no express prohibition to do with pregnancy dismissal, unlike the Equal Treatment Directive. So the Court of Appeal said, no, we cannot use this Equal Treatment Directive and protect your rights. However, the House of Lords, the same Lord Keith, said we were under an obligation of using the purposive approach and granting this woman her rights. It would seem that indirect effect could apply to almost any legislation. However, this is not true. Even the ECJ has admitted there are times when the indirect effect doctrine cannot be utilised. So, for example, where national legislation conflicts with the relevant directive, then you can't use it. So in the case of if a directive says not to do something and yet the national law says you can do something, reading in the not is just a step too far. And this was confirmed in the case of Wagner and Mirret, where the Spanish law excluded something that the directive prevented, and there was a conflict and indirect effect could not be used. Similarly, indirect effect could not be used where it's used to impose a criminal liability. So in the case of Accaro, he was guilty under the directive but not under the Italian national legislation. You cannot use the directive in order to make him guilty because it would be unfair and retrospective. In conclusion, then, indirect effect is an interpretive tool requiring the courts to use a purposive approach when reading national legislation so that it's in line with EU law. Essentially applies to all law despite the implementing and non-implementing distinction. However, it's important to note there are two occasions where this process or tool will not apply, and that is where it conflicts with national legislation quite clearly and where it imposes a criminal liability. Thank you for watching.